During a deposition, if the opposing lawyer fails to ask you questions about certain elements of your damages, of the problems that you're having, can I go ahead and ask you questions at the end? Would you like to know the answer? Come join me by the marina as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is yes, I can. The defense attorney may spend hours and hours asking you every question under the sun, asking you about your medical history, asking about things that you've done in the past, asking about problems that you've had in the past, as well as problems that you have currently and problems that you expect to have in the future. If the defense attorney does not ask you certain questions about your injuries or your damages, or only touches upon them, do I have the ability to go ahead and ask you follow-up questions? The answer is absolutely. You bet I do. So now, after many hours of being questioned by the opposing attorney, if I feel that there are certain questions that need to be followed up, I will go ahead when he is done questioning you and now go ahead and turn to you. Okay, Mr. Jones, I know you were asked a question about this injury that you have, but I want to know, and now I'll go ahead and ask you further follow-up questions. Can you tell me what happened when this incident occurred to you? How did that make you feel? And now I can go ahead and have you explain to us and to the defense attorney exactly how that made you feel. Now, why is it important for me to ask follow-up questions? It's critically important because if I feel that the defense attorney has not gotten certain information out, I want to be able to get that information out. Now, why is that important? It's important for two reasons. Number one, your testimony, the answers that you give to the questions you are being asked, can be used against you if the defense makes a motion for summary judgment. You see, when all discovery is complete, the defense will oftentimes try and do everything possible to get your case thrown out before we ever get to trial. And there is an opportunity for the defense attorney to try and do that, and they have to do it with the testimony that's been given in your case, as well as the medical records and any experts that support their position. If the defense attorney asks you a question about your injuries and your damages, and you are not articulate and you don't explain sufficiently about the problems that you have today, they may use that to say and to argue that your injuries are not very significant because, look, this patient says, Mr. Jones says, he doesn't really have any problems now. If that were true, now you're going to be in a very difficult position to say later on that you have extensive injuries. So by following up and going ahead and allowing you to explain your answer to certain questions, that now solidifies and confirms that you have definite injuries, so that if the defense tries to make the argument that your injuries aren't that bad, well, now we have sworn testimony from you explaining how bad your injuries are and what limitations and disabilities you have because of those injuries. Now, how else is it used? Another way it's used is that it gives the defense attorney more information to report back to his principals so that they have a better understanding about how this malpractice affected you and how it affects you on a daily basis. If you do not use the opportunity to go ahead and explain to them exactly what problems you have and how it's affected you, now they are limited in understanding and will believe that the injuries that you have are really not that bad, and it will affect the value of your case. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.